All right, everybody, welcome back to Just in the Nick of Crime. I know it has been a minute, but trust me, we have a lot to talk about. And I'm going to go ahead and say this up front. This is a big live. There are major updates in the Jesse Mack Butler case. I've received several new documents, and we're going to walk through all of it very carefully. This is a lot of information, so we're going to take it piece by piece. Now, before we get into all the heavy stuff, I do want to knock out a few housekeeping items really quick. Now, first, sorry, I got two screens over here, so first thing I want to show you guys is this. Sorry, got to do it. My book, Boundaries. My wife wants me to get rid of the additional copies that I have. And with Christmas coming up or holidays, Hanukkah, whatever you celebrate, I just want to remind you that Boundaries is still available. If you like to pick up a copy, hardcover or soft, you can do so at my website, justthenickofcrime.com, or at the TikTok shop. Each copy will come signed, and I can dedicate it if you let me know who you'd like that dedication to. It's a great way to support the work that I do, and then you get something in return for it. You get a physical book that I will mail. If it's before the mail came, it'll go out the same day. If it's after, it'll go out the very next day. I promise you, you'll get it very quickly. For context, the book was written because, as a lot of you guys probably know, I'm no contact with, well, both my parents, and I have a 6-year-old daughter who sometimes wonders why. This book has become a really helpful way to explain that to kids without speaking negatively about the people you're not in contact with and without putting adult issues on their shoulders. It explains that sometimes adults need space to stay healthy and safe, just like kids do, and that boundaries inside families are normal, loving, and okay. It teaches kids that they are allowed to have boundaries also, even with the people that they love, which is something that, with all the stuff that I talk about, is a very important message. It also tells them that protecting your peace doesn't mean that you don't care. It's a very gentle, age-appropriate introduction to what boundaries are, why they matter, and how they keep relationships safe and healthy. Now, the next thing that I want to talk about is an update on my podcast. These are my only two real announcements, guys, and then we're getting into the meat of this. As a lot of you guys may, and some of y'all might not know this, I am getting ready to launch a new podcast in January. It's now going to be launched in January, called Unheard: True Crime in Their Own Words. Well, it's officially moving forward. I am in the final stages of actually signing a contract for distribution and marketing with a large media company. And we have some really big guests coming up, names that you will absolutely 100% recognize. I'm talking about big names in the space that we're talking about. I can't announce them just yet, but trust me when I say that this podcast is going to be something very different and very important. And I can't wait to share more. What I will tell you, though, real quick on it, is that the idea was born from Gabby Petito's mother, Nikki. She had said something to me, and I was like, oh my gosh, we have an idea to do this. So it's something that's different, that's not being done anywhere else. And I'm very excited about that part. And lastly, just a quick reminder, if you are watching live or on replay, make sure that you are subscribed, turn your notifications on, and feel free to drop comments as we go. This is one of those conversations where your voices 100% matter. They have mattered this entire time. And seriously, I'm not against pandering for followers and subscribers. I'm trying to reach a goal on YouTube of 10,000 subs. I'm at like 61.6 and change right now. So I have a bit of a way to go, but I really want to get that 100,000 plaque that YouTube will send when you hit 100,000. So please sub. If you're watching somewhere else, jump over there and sub. And if you're watching on Instagram, Facebook, or YouTube, or TikTok, please sub there. And if you are on TikTok, you will not see any of the images that we're talking about. You can still hear, but you might want to jump over to YouTube if you want to do that. Links in the bio. All right. Now, with that out of the way, housekeeping stuff out of the way, I want to address something that a lot of people have been talking about, because we've heard that Jesse moved to Guthrie. He did not. But let's talk about where Jesse Mack Butler is right now. I received information today, a short while ago, that Jesse is currently staying at his sister's house. Now, I don't know at this point whether that's a permanent arrangement or a temporary one. I'm sharing this because many of you guys have asked about his current location. If that information changes or I'm able to confirm anything further, of course, I will be there to update you guys. Now, before we move into the transcripts or anything else, we need to start here, because this document sets the tone for everything that follows. What you're looking at on screen is the Youthful Offender Court Report prepared by the Payne County Office of Juvenile Affairs. This report, as you can see, is dated, well, maybe you can't see because it's kind of small, but it's dated December 3rd, 2025, and it's meant to inform the court how Jesse Mack Butler is doing under his supervision. Now, this report is supposed to help the judge assess compliance, risk, accountability, and public safety. And I want you to keep that purpose in mind as we go through this, because according to this report, well, not because, but according to this report, Jesse was placed on what's called intensive community supervision, which includes daily phone check-ins and weekly in-person visits. The report tells you, or tells the court that Jesse has called in every single day except for 2 days. And by the way, real quick, I know that this came out a couple days ago. I talked about it, but we're doing a whole big gauntlet on everything. And I think that this is a very important document, which is why I'm starting with it first. I think that it sets the tone for everything that we're going to talk about today. Now, again, like I said, according to the people, the court was told, the report tells the judge, that Jesse has called in every day except for 2 days. On the first missed call, he just simply forgot to call. And on the second missed call, the report says that he stayed in bed late because of an issue with his eye and that he reports seeing a physician. So that's it. There's no concern expressed. There's no follow-up documented. There's no discussion of credibility or reliability. Instead, the report explains that to make up for the missed calls, Jesse was required to add an extra in-person visit that week. And then the report moves on. It then discusses education. It tells the court that Jesse attends school still through Stillwater Public Schools, but he's now using an online program called Edgenuity. I think that's how you pronounce it, Edgenuity, Edgenuity. He's classified as a senior, and the report states that school is going well and lists his classes. A grade printout is attached, although what's notable is that that is sealed. His grades at this point are sealed. What's also notable is what's not discussed. There's no mention of how this placement was chosen, no discussion of safety considerations, no reference to victims' proximity or impact. Education is presented as a neutral success marker. The report then moves into substance use. We're told Jesse submitted 2 substance tests. I'm trying to keep it social media safe. Substance tests since October 6th. Both were negative, which, I mean, honestly, I don't see him as being a substance user. I mean, anything other than possibly and I don't think he's on steroids either, but like, I mean, he's an athlete. So I don't see him using like hardcore substances, but whatever. So both came back negative. A screening tool called the SASSIA or SASSIA-2. That's what they use to administer. That's not a diagnosis, but a screening tool. And the report says that he scored low probability of having a substance use disorder, though it notes mild concerns could warrant further assessment. Again, framed very positively in Jesse's case. Then we get to therapy. And this is where I need you guys to really pay attention, okay? Because the report states that the core of Jesse's rehabilitation plan rests on weekly counseling with a licensed clinical social worker. It notes that family members participate in therapy sessions. The worker requested a progress report for the court, and the family provided a spreadsheet showing attendance dates. What the report does not include is any detailed discussion of accountability, behavioral change, or acknowledgement of harm. The report relies heavily on self-reporting and family-provided documentation, meaning that they're taking his word for it. It's like the trust me bro system, right? Next, the report addresses community service. And I find this really interesting, right? Because originally he was ordered to complete community service through something called the CLEAN program. That program denied his participation. Basically, they said that they didn't want him. But rather than that being flagged as an issue, the court the report explains to the court that an alternative nonprofit placements were approved that the family located for him. Jesse began service work on December 2nd, and the worker suggests bringing verification to hours completed. Now, I do want to talk about something real quick on this because I've known people to do community service because they had to, legally speaking, they had to. And if they knew somebody, it's like, hey, can I do this? Can you guys just sign off on it? So I don't know what program Jesse's in, and I'm not saying he is or he isn't, but I'm saying with the connections the family has, it wouldn't surprise me if Jesse wasn't actually doing anything. All right. That's what I would say, in my opinion. But again, this shows that the system is adapting around him. Oh, this program didn't work. We're going to let you do what you want to do. We're going to let your family find a place, whatever. Then we come to the victim-related portions of the report. Now, part of Jesse's rehabilitation plan required to attend a SA victim impact panel. So I'm trying to keep it social media safe today. The report states that no panel has been located. They can't find one. And as an alternative, the court has not enrolled him, may consider a domestic violence course, possibly one available even online. That is what is written. An SA case and the victim impact requirement remains unresolved, and they're going to downplay it into something even lower. The report then states that no violations of protective orders have been reported or made known to the office. There's no explanation of how any of that is monitored, though. There's been no discussion of victim input, no description of enforcement mechanisms, and on the final page, the report discusses a safety plan. It states that a safety plan was developed and signed by the family, reviewed monthly, and attached to the report. So, again, safety plan developed and signed by the family, not by the court, not by the judges, by the family. And then we get to risk assessment. The report says that the Office of Juvenile Affairs is currently working on securing a provider for a formal risk assessment, which is like such as the SAVRY, SAVRY, which is commonly used for violent or S offenders. The plan is to administer that assessment approximately 6 months into supervision. 6 months, meaning that at the time of this report, a formal risk assessment has not been completed. Right? It's not been done. The report then outlines Jesse's daily life. And I love this part, guys. I love this part because it states that he spends most of his time at home. He does laundry, he cooks, he does schoolwork, he spends time with his family, plays board games, builds Lego sets, watches his sister's dog, cooks with his mom. I don't know if he cooks out, but cooks with his mom and watches TV. That's what the court is told. Finally, the report discusses technology restrictions. Jesse reports that he deleted all social media from his phone. He denies ever having a Tinder account. He says that his phone requires permission to add apps, and he denies any social media usage since deleting those apps. Now, the report ends officially by stating that there are no new referrals, and because Jesse has reached the age of majority, meaning over 18, or he is 18, any new referrals would be handled through the adult system. That this is the Youthful Offender Court Report. The document, guys, it's calm, it's orderly, it focused on routine, compliance, and daily life. And as we move forward tonight, I want you to remember how this report frames Jesse, because everything else we're talking about and everything that we're going to look at tonight, for the vast majority of it, is going to contradict that. So now that you've seen the Youthful Offender Court Report that frames Jesse Mack Butler on paper, we need to look at what actually happened when everyone walked into that courtroom the other day on December 3rd. Was it the 3rd? It was the 8th, I think. It doesn't matter. Yeah, December 8th. Because this next document shows how that framing plays out in real time. So what you're looking at on the screen is the first page of the official transcript of the review hearing that was held, like I said, on December 8th in the District Court of Payne County, Oklahoma. This is a certified court's transcript. Actually, let me do this real quick. Special shout out. Where is it? There's to my good friend, Missing USA, Dan. He helped us procure this. It did cost us money to get it, a good amount of money to get it, but we felt that it was worth it. So we spent the money and we did it. Hence, again, clear way to help support the channel. Go buy the books or whatever you want. Do what you want. Do what you want. But I want to walk you through how this hearing unfolds because I feel like the priors are very clear here. So the judge opens the hearing by explaining courtroom procedure. That's standard. Everybody's going to do that. And it's Judge Michael Culling is the one who's presiding over this. He reminds everyone. And by the way, I want you to remember that name, Judge Culling. I want you to remember it because we're going to talk about him in a little bit later. Okay. But he reminds everyone that the proceedings are being transcribed, that a court reporter is present, and that members of the public are allowed to observe as long as they follow the rules. Right away, notice what this establishes. This is treated as a routine compliance hearing, which it pretty much is. Then the court explains the purpose of this hearing. This is not to review or determine whether Jesse is in compliance or non-compliance with the written rehabilitation plan that was previously adopted. The judge states for the record that Jesse entered a no contest plea as a youthful offender, that the plea was accepted, and that he remains subject to the sentence imposed under the Youthful Offender Act. That's the framework. Next, the court explains that it has received several documents in advance of the hearing, including the Youthful Offender Court Report, which we just went through, a letter from Jesse's therapist, documentation regarding restitution, and there was restitution like $3,000 and change, like $3,200, and a community service document. Those are the materials guiding this review. The court then allows the Office of Juvenile Affairs to speak first. The OJA reports that Jesse is operating under the rehabilitation plan as expected. The representative tells the court that Jesse is on intensive supervision, which we talked about earlier. He checks in daily, that he has in-person visits, and that he is, in their words, in compliance. The court asks a very direct question. Is Jesse in compliance with the rehabilitation program? And OJA says, yes. Then the state is asked if they are aware of any violations. The state says no. The defense counsel is asked if they have anything to add. Defense counsel says that they believe Jesse is in compliance and will continue to be. Up to this point, the entire conversation centers on Jesse's compliance. The court then turns to the victims. The victim's attorney, who is there, along with the victims and their families, raises concerns. She states on the record, guys, that victims have concerns about whether Jesse has acknowledged wrongdoing, whether that acknowledgement is being addressed in counseling, and whether there has been any admission of guilt that would make treatment meaningful. She specifically questions how rehabilitation can occur without accountability. And that's a very valid point. If he hasn't admitted to any wrongdoing, then what are they talking about in these counseling sessions, right? Are they just going through this to check a box? Is this somebody the family knows? I don't know. Hopefully not. But this is one of the most important moments in the transcript because the response is not to explore these concerns. Instead, the court explains that the sealing rules under the Oklahoma Youthful Offender Act, okay, that's what he does, talk about the sealing rules. The judge explains that certain documents remain sealed, that some documents are unsealed, and that the Youthful Offender Court report itself will be removed from seal and made public, which is why we were able to just go through it a second ago. But all the while, attachments related to education and treatment will remain sealed. So the concern raised by the victim's accountability is not really addressed. Basically, they're saying, well, we're not going to tell you whether they're addressing or not because we're going to keep this sealed. The hearing then moves on. All right. Next, the court asked about community service. It's acknowledged that Jesse was denied entry into the CLEAN program. The response is that alternate placements were approved and that he has begun service. I believe that service started on December 2nd. Again, the system adapts around Jesse. The court then discusses missed check-ins. We hear confirmation of exactly what you saw in the Youthful Offender Report, that Jesse missed 2 check-ins, that he was required to come in extra times to make up for it, and that this was handled administratively. No sanctions are discussed. No consequences are imposed. Then the court speaks directly to Jesse. The judge reminds him, okay, the judge is speaking to Jesse at this point, reminds him that if the sentence were to be enforced, he could be sent to the Adult Department of Corrections for a lengthy period of time. The judge emphasizes that Jesse is now an adult and asks if he understands. Jesse responds. He says, yes, Your Honor. He is asked if he has any questions. He says no. The court then schedules the next review hearing for April. I think it's April 26th, if I'm not mistaken. So, of course, we'll be covering that. And that's the end of the substantive discussion of the of these transcripts of this hearing. And I want you to pause here and think about what you just heard. The transcript is very calm. It's orderly. It's very procedural, right? There is an extensive discussion of Jesse's compliance, supervision level, therapy attendance, education, and scheduling. But what is missing is just as important. Again, no meaningful discussion of the victim's trauma, no exploration of their safety, no examination of how accountability is being measured, no response to the concern that rehabilitation without acknowledgement might be meaningless. And when you place this transcript next to the Youthful Offender Court report, you see a pattern, right? On paper, Jesse is described as compliant, stable, and progressing. The courtroom, that framing is accepted, reinforced, and moved on without any type of challenge. Now, before we move on, we need to stop here because this document that I'm going to show you next represents how the state of Oklahoma is publicly explaining everything you've seen so far. And in my view, this statement exists because of you guys. This entire statement that we're about to go through is because of y'all. Because people show up online, because people showed up in person at these rallies, at these protests, because petitions have been signed, because emails have been sent, calls have been made, because this case did not quietly disappear as the officials in Payne County wanted it to. So great job, guys. You guys made this statement happen. And we're going to talk about this statement. Before I do, I want to be clear about something up front. Every document I've presented so far, including this one that we're about to talk about, is already posted on my Instagram in full for anyone who wants to read them word for word in their entirety. Nothing is being selectively quoted. Nothing is hidden. What you're looking at now is a written statement from Payne County District Attorney Laura Austin Thomas, issued in response to requests for comment regarding the prosecution of Jesse Mack Butler. All right, guys. And I might have to get up and grab a drink here real quick. My throat's very dry. We'll see. We'll see how far I can go. So I'm going to read this verbatim because I think that the wording matters, and we're gonna break it up a little bit, but I'm going to read it verbatim. Okay. So in response to a number of requests for comment regarding the state of Oklahoma's prosecution of Jesse Butler, District Attorney Laura Austin Thomas has provided the following statement. Quote, the District Attorney's Office carefully evaluates every case submitted for prosecution to determine the strengths and weaknesses of the available evidence and potential defenses. Let's pause there. That opening sentence establishes the entire tone of the rest of this message. It positions the office as careful, measured, and objective. That's what they want you to think, but keep listening. And again, guys, there's going to be a lot of bias from my end on this. I'm just going to tell you that right now. So if you wanted to read it again without bias, without my interruptions on my Instagram. So let's continue. Quote, the charges in this matter allege conduct by a 16-year-old male directed at similarly aged young women. Most crimes, you know what? I'm going to stop there for a minute. One thing that I hate, is how often these types of situations take underage girls, take minors, and be like, "Hey, they're young women." No, they're girls. They're girls. They're young girls. They're under the age of 18. I just hate that. I got to say something. All right, I'm gonna start it over. Sorry. So the charges in this matter allege conduct by a 16-year-old male directed at similarly aged young women. Most crimes committed by persons under 18 must be filed in juvenile court, where proceedings are confidential and have no potential for incarceration in the adult system. Now, I want you to notice what's happening here. I'm going to end quote. Notice what's happening here. The focus right on this part is on age, on limitations of the system, on what the law can't do, not on what the evidence did show. And that matters because this case was initially charged in adult court. He was facing 78 years, right? That means there was sufficient evidence at filing to pursue adult prosecution for violent S offenses, including forced S assault and strangulation. So this was not a case where the state lacked evidence. This was a case where the state later chose a different path, right? Youthful offender. Let's continue. A significant number of more serious crimes provided the option of filing as a youthful offender. As a youthful offender, the accused has an opportunity for rehabilitation, but can be transitioned to adult status and adult punishment if those efforts fail. Now, this is where the framing becomes critical. Rehabilitation first, accountability later. Something goes wrong. Something goes wrong. But that framing avoids a fundamental question. What qualifies then as a serious crime to begin with? Because the record in this case includes allegations of forced S assault, strangulation, and significant medical injury, including one victim who required surgery, one victim who, according to her physician, was 30 seconds away from death. Those are not minor offenses, y'all. Those are not borderline cases. Those are inherently violent crimes, and ones that I will argue can't be rehabilitated. And continuing. Quote, the youthful offender sentence imposed against Jesse Butler requires him to complete his rehabilitation plan successfully, including an aggressive schedule of therapy with a specialist and a S offender treatment. And should he fail, he faces reclassification as an adult and a sentence of 10 years in prison. Now hold on to that phrase, should he fail, because it places accountability in the future, again, not the present, not for what he's already done. Now the statement then shifts. Years of experience tell us the jury, this is the part, oh, guys, I need y'all to listen so carefully, guys, to this part, okay? Very carefully. Quote, years of experience tell us that juries often struggle with convicting defendants based upon delayed reports of S assault between people in ongoing consensual dating relationships. And the trial process can be very traumatic for victims, end quote. This sentence matters because here responsibility subtly shifts, right? It shifts from the accused to juries, to reporting timelines, to the difficulty of prosecution. And that context matters because this case was not built solely on circumstantial evidence. According to information already in the record, as we know, there are medical evaluations, there were witnesses, there was video evidence on his phone, reportedly recorded by Jesse himself depicting strangulation. So this was not a case resting entirely on delayed disclosure or credibility disputes. There was corroborating evidence of violent conduct, and that's also important to say this clearly, because strangulation, guys, this is really important. Strangulation is one of the strongest predictors of future lethal violence. Let me read that again. Strangulation is one of the strongest predictors of future lethal violence. It is recognized in both medical and criminal justice research as a key indicator of escalation towards homicide. And here the allegations include strangulation severe enough that one victim required surgery. And I also want to talk about a little bit more. Okay, because here's the thing. They talk about juries having an issue convicting people in consensual S relationships. Well, here's the way consent works. Consent can be revoked, y'all. Consent can be revoked. And having things done to you to the point that you bleed, that's not consent, especially when they said no. When you have somebody hold you down and say that they will end the lives of your families if you don't comply with what their conquest wants to be, that's not consent either. When you have a situation where somebody is holding you down and forcing you, that is not consent. You know, the thing about consent is that you could have been intimate with a partner 100 times. one time they could say no. That if you keep doing it, that's not consent. It's been revoked. And I think, again, like I said, when you look at the evidence that you have, this hard, substantial evidence, I think that the jury would have no issue. On top of that, they're by saying that, oh, well, because of the delayed reporting, that's putting the fault back on the victims, right? That's saying, oh, well, you guys didn't report it soon enough, so this is your fault. We can't try him under a jury trial. It's gaslighting, victim blaming, victim shaming, right? Whereas it honestly wasn't that delayed. We're talking like, I think at most 6 months. I don't know if Amber's in here or any of these watching, but if Amber's in here, you can tell me. But I don't think it was really that delayed of a report. And even if it was, 6 months isn't that long. And a lot of girls and women take time to come forward because of what they've gone through, and because of the victim blaming, because of the victim shaming, right? I mean, that's not uncommon. Anyways, let me continue. Quote, nonetheless, after consultation with the victims and their families, we chose to file this matter and to file in adult court rather than juvenile in order to bring the serious behavior at issue into the public eye with hopes of avoiding a later reclassification of the case to juvenile status. Now, this is an important claim as we'll come back to it. Okay, continuing. In accordance with Oklahoma law, this filing decision then afforded the defendant the opportunity to seek certification of his charges to youthful offender or juvenile status. Again, opportunity. Continuing. We explained that youthful offender was the most likely final outcome, particularly because the 2 counts of attempted that sounds like the word grape, were the only alleged crimes among the 11 charged that even qualified for the case in the case for filing in adult court. And basically she's saying only those 2 counts are what qualifies for adult court, hold on. And additionally, because existing law strongly favors providing offenders under 18 an opportunity for rehabilitation. Now, this is where many people struggle to reconcile the explanation with the facts, myself included. In fact, I'm very much struggling with it. Okay? Very much struggling with it. Because strangulation, especially to the point of oxygen deprivation, is commonly treated as attempted homicide in other jurisdictions. So the question, in fact, there's actually an ICE agent that just got arrested in Ohio who had 22 domestic violence calls to his house before he was finally arrested with strangulation. I think he's being charged with attempted murder. All right? 22 phone calls over 18 months. Strangled his partner. Right? But not Jesse. Not Jesse. Okay? So the question that many are asking is not whether the law allows rehabilitation, but why conduct of this severity was not changed or charged, I should say, or treated to the level of severity that it actually is. That's my question. Now, the final paragraph. The ultimate resolution of the case reached without either victim having to testify or face cross-examination in a contested proceeding included the accused agreeing not to challenge any of the allegations and to be sentenced to the outcome described above, including the potential for imprisonment in the penitentiary. And this is another place where context matters. The victims in the case were willing, able, and prepared to testify. They wanted to testify. They were not seeking to avoid the process. They were prepared to use their voices. They were prepared to stand up. So when the state frames this outcome as sparing them trauma, despite the fact they've already lived through trauma, it raises a real question about who made that determination and when. That's the DA's statement in full. It's calm, confident. It's carefully, very carefully worded. But in my opinion, it is a lot of gaslighting. Okay. The other thing that I want to say is that the victims and their families, despite the fact what Miss Thomas wants to say in this document, were not consulted to this plea deal. And when the few times that they were talked about with this type of a plea deal, they vehemently objected to it. So no, it was not with the consent of the victims and their families. Now, I want you to hear something very different because next we're going to listen to the words of a victim. Okay, we're going to listen to one of the victims. All right, I was sent the entire victim impact statement. And then we're going to place those words side by side with this explanation. All right, and I'm going to put this up on the screen because I want to remind you as I'm reading this victim impact statement, these are his charges. Okay, what you see up there, those are his charges. Okay. So we're going to listen to the words of the victim, then we're going to place those words side by side with this explanation. and the next a legal filing that says victims' constitutional rights were violated. And when you do that, the contradictions become impossible to ignore. Now, before I go further, before I read this, I need everybody watching to understand what you are about to hear. Okay. I want you to really comprehend this. Okay. Because what I'm about to read is a victim impact statement, not commentary. It's not interpretation. It's not opinion. These are the actual words verbatim of one of Jesse Mack Butler's victims submitted to the court. Like I said, I'm going to read this verbatim without interruption. So please listen very carefully. This is powerful. I'm going to give you a warning that's going to be hard to listen to. This is what this 16-year-old girl, this child, went through. Okay? I never imagined I'd be standing here needing to explain the harm someone did to me or trying to make people understand the damage that has been caused. You didn't just hurt me physically. You took pieces of my safety, my peace, and my sense of who I was. What you did wasn't just violence. It was betrayal, fear, shame, humiliation, and pain layered over and over. And it didn't stop when the assaults ended. It followed me every single day afterwards. I've had to carry this weight while going to school, trying to act like I'm okay. I've woken up from nightmares that make me feel like I'm being attacked all over again. I've had to explain bruises, explain silence, explain why I started isolating from people who loved me. You didn't just strangle me with your hands. You strangled my voice, my joy, my ability to feel safe in my own body. And even now, months later, I still don't feel safe. Jesse didn't just abuse me. He threatened me over and over again. He told me that if I ever told anyone what he was doing, that he would kill me, that he would kill my family. He would kill himself. He even threatened to hurt or kill his own family. Do you know what it's like to live with that kind of fear at 17 years old? To walk into your house wondering if today's the day someone follows you home? To be afraid that opening your mouth could cost someone else their life? Those threats silenced me just as much as his hands ever did. I was terrified. Every time I thought about telling someone, I heard his voice in my head reminding me that if I spoke up, he would be there to silence me, and I believed him because he had already shown me what he was capable of. He showed me when he forced himself on me while laughing at my tears. He showed me when he put his hands around my neck and squeezed until I passed out in the Walmart parking lot. When I finally did get the courage to speak, I did so knowing I might be putting my family in danger. That's a decision no one should have to make, but I had to. I hope that one day you actually face what you've done. Not just get punished, but really face it. Every time you ignored my no, every time you forced yourself on me, every time you laughed while I cried, I hope you understand how much it haunts me. You tried to make me feel powerless, but I'm taking that power back today. I will not let your violence define who I am. I am a survivor, not your victim. You didn't destroy me, even though you tried to. But I won't pretend I'm okay. I'm still healing. I am still afraid. I still carry these memories in my body and my mind. And while I may learn to live with them, I will never forget what you did. I will never forget Marble Slab when you pinned me down, touched my body without permission while I begged you to stop. I screamed no over and over, and you ignored it. I will never forget what it felt like when you pinned me inside your truck and said, "You're not going anywhere until I finish," like I was something just to be used. I will never forget the way you threatened me when your mother called. You made me lie. I wanted to scream for help, and I couldn't because I didn't know what you would do next. I will never forget the Planet Fitness parking lot and the panic, the way I felt like my body didn't belong to me anymore. I will never forget the night you strangled me unconscious because I said no. That moment changed my life. A medical professional later told me that I was just 30 seconds away from dying. 30 seconds. If you had kept your hands on my neck just a little longer, I wouldn't be standing here today. That wasn't just a scare. It was a near-death experience. You didn't just hurt me. You nearly killed me. And because of that one act of violence, I had to have surgery on my neck. The damage you caused wasn't invisible, and it wasn't temporary. The pain lingered for months, and now the scar is something I'll carry for the rest of my life, a permanent reminder of what you did to me. To Jesse's parents, I don't know what you knew. I don't know if you heard me crying through the walls or noticed how your son treated me when no one was looking, but I hope you hear this now. Your son hurt me in ways that cannot be undone, and I need you to understand that your silence, your protection of him, or even your denial, that would hurt too, because someone should have stopped this. Someone should have seen the bruises and the fear. The statement is not just for the court. It's for Jesse. It's for his family. It's so none of you can pretend you didn't know what he did or how deeply he broke me. And for the people in this room who are deciding his punishment, I need you to remember that what happened to me wasn't only abuse or strangulation. It was nearly attempted murder. So I ask that you hold him accountable to the fullest. 30 more seconds in this world, this would not be my statement. It would be my mother's, because I would not have survived. I survived what he did, but I will never be the same. I want you guys to take a moment to digest that. That was the entire statement. It's incredibly powerful. It's really hard to read. It's really hard to listen to, I know. But those are the words no kid should have to write. There's no, that's her detailing what happened to her. They're the lived consequences of what you heard described earlier as a matter of rehabilitation, procedure, and future accountability. You heard her talk about a near-death experience described at first person. You heard strangulation described as it happened. You heard surgery described as a result of that violence. Those are the words of a 17-year-old girl, one strong enough and brave enough to stand up and use her voice only for the court system to silence her. And now, after hearing that, we're going to look at the legal filing that says this victim's constitutional rights were violated, not just hers, but the other one too, during this entire process. Because when you place these words next to the state's explanation and then next to the law, the contradictions become honestly undeniable. So we just heard the victim impact statement, guys. It's hard, y'all. Let me do a quick check-in with you guys. Are y'all here? All okay? You guys okay after hearing that? And real quick, I see people asking, while I'm taking a break, letting y'all digest and get your bearings on that. People who were saying I missed it, I came in late. This is on YouTube. It is saved. You can go back and watch it from the very beginning if you came in late. Okay. If you want to see the photos and things that we have coming up, we're going to have Representative J.J. Humphrey come on probably very soon to talk about the Grand Jury Petition. So if you want to see that, you'll have to. In fact, he's already sitting in the wings. He's waiting on me. You're going to have to jump over to YouTube on that. Okay. But yeah, if you've missed it, that's what you can do. So now let's talk about what happened after, because this is where the legal side of the case really comes into focus. So following everything you've heard up to this point, the victim's attorney filed a verified motion to enforce victims' constitutional rights. First page of that is here. This has not been put up on Instagram yet, but it will be soon. It's about 20 pages long, which means on Instagram, I'll have to do it in 2 posts. On Facebook, I think I can do it in 1. And it lays out step by step how the victim's rights were handled, or more accurately, how they weren't. This motion is based on Marcy's Law and Oklahoma's Victims' Rights Act. Those laws are supposed to guarantee victims basic things like notice of hearings, the right to be consulted before plea deals, and the right to be heard, and the right to participate meaningfully in the process. Now, according to this motion, that didn't happen here, guys. One of the words used in this filing is illusory, meaning that the rights existed on paper, but not in reality, meaning it was an illusion. The motion lays out that the victims and their attorneys were not properly notified about multiple hearings that they had a legal right to attend to. Filings weren't served correctly. Orders were entered without their knowledge. Key decisions were happening without them even in the room. In fact, at one point, y'all, the families were given 10 minutes notice before the plea was entered. 10 minutes to process what was happening. 10 minutes to talk to their attorney. 10 minutes before a life-altering decision was finalized. When the victim objected to the plea in court, the plea still went through. They didn't care. The motion also says the victims were not interviewed for the pre-sentence report and were not given a chance to correct or supplement it. So the court relied on a report that didn't fully reflect their experience, even after everything you just heard in the statement we read. And this is where the contradiction becomes impossible to ignore. You heard the district attorney say that the resolution avoided forcing victims to testify, right? That's what she said. You heard a victim say that she wanted to testify, that she was willing, that she was ready. She wanted her voice to be heard. She was taking the power back. And according to this motion, the problem wasn't that the victims didn't want to participate. It's that the process moved forward without allowing them to do so in a meaningful way. The filing also lays out the pattern of violence in this case, not one incident: escalation, strangulation, SA, threats, conduct that a medical professional later said left the victim 30 seconds from death. And despite all of that, The outcome was a plea with 0 incarceration. So what is the victim asking for here? Well, she's asking for the court to acknowledge that her constitutional rights were violated. She's asking for the plea to be revisited or at least corrected. She's asking for a process where her rights actually matter, not just on paper, but in practice. And when you put all this together, the Youthful Offender Report, the transcript, the DA statement, the victim impact statement, and now this motion, a clear picture starts to form. This isn't just about sentencing. This is about whether victims' rights mean anything when it's inconvenient to honor them. And that's where this case stands right now. So real quick, before I bring Representative Humphreys on, I do want to take a step back from the documents for just a moment, because there's something else that matters here. And frankly, it's not in any of the documents. It's what happened outside the courtroom. On the day of this most recent hearing on December 8th, Jesse didn't leave through the front doors of the court. Okay, guys? He was escorted out the back, and the media redirected away from him. At the same time, though, the victims, who are minors, still minors, were sent out through the front straight into waiting cameras. That didn't happen by accident, guys. Courthouses don't work that way. Someone made a decision about who needed to be shielded and who didn't. And the result was that the person accused of violent assault avoided the media, while minors who survived it had cameras shoved in their faces. And after everything you've heard, that choice says a lot about whose comfort and protection was prioritized in that moment, and it sure as hell wasn't the victims. And that brings us to the latest development. This is a big one, y'all, because you've already learned about some of the alleged corruption, and we're going to talk more about that, because this is no longer just about one case or one courtroom. What I want to talk about now is something that was filed yesterday. All right. And I want to be very clear. I think it's important to be clear about what this is and what it isn't. This is a grand jury petition that was filed in Payne County yesterday. A grand jury petition is not a lawsuit. It's not a criminal charge. It's not a finding of guilt. What it is a formal request asking for an independent grand jury to investigate whether crimes or misconduct may have occurred, not by a defendant, but by officials and institutions. This petition is extensive, y'all. It is 16 pages long, and at a high level, it asks for a grand jury to look into whether people and agencies who are supposed to protect children instead failed to do so, covered things up, or actively interfered with investigations. And according to the petition, the requested investigation includes, among other things, allegations of failures to report abuse, falsifying or withholding documents, obstructing investigations, misuse of public funds, and patterns of conduct that allegedly allowed abuse to continue. It names multiple agencies and officials, including child welfare entities, prosecutors, judges, and oversight bodies, and asks whether their actions or inaction harmed children in Payne County and beyond. Again, this is not about one case when we're talking about this grand jury. And this is where it connects back to everything we've talked about today. When people start asking questions about whether victims were shut out, when violent conduct appears minimized, when transparency breaks down, a grand jury petition is one of the only tools citizens have to say, we need an independent look at what's happening here. All right. Now, again, I'm about to bring on Representative J.J. Humphrey from Oklahoma. He has been key on this. He's the one that filed this. If you are on TikTok, you're going to need to jump over to YouTube if you want to hear it. If not, you'll just hear one side. Hey, Representative, how are you doing today?
What do you know?
So sorry, I didn't mean to keep you waiting in the wings for so long. But,
no, listen, man, you're doing all the great. You keep on it. You just keep on. You're doing awesome.
Well, I appreciate you. Well, I wanted to bring you on because this was filed yesterday, and I figured, because you're the one that helped author this, you're the one that filed it. You could maybe bring a little bit more nuance to it, kind of what you're planning to do with it or what the goal. And of course, we need to remind the people of Payne County to show up and show out when it's time to get signatures.
Absolutely. I think we're going to get that. I think there's a lot of attention on that. The question is, I can promise you right now, there's a bunch of legal minds in Oklahoma sitting in a room trying to determine how to kill this thing or how to kill old J.J. Humphrey. One or the two, you know what I'm saying? There's going to be a lot of people. We got the entire Supreme Court justice on that. You know what I'm saying? We've got the entire judicial complaints, and rightly so.
Well, what else do you want to walk the people through? Kind of. Well, first, let's talk about, before we get into what's in the petition. Let's give people a reminder about the signatures. If I don't know if you still need volunteers, but if so, how to get a hold of you for that and what you need to do and when. for this to become successful.
Sure. Yes. Right. So what we're doing is that what we're going to set up. So here's the thing. We file this petition. We have roughly 4 days that the judge can have 4 days whether to approve the petition or deny. So if they deny the petition, then what you're looking at is that we have 2 days to respond to what they refuse to file this under. So we can fix it and have 2 days to fix it. So, I mean, those are really questionable practices. We need to change that. Once we're approved on that, so we'll know pretty quick, probably around next week, mid next week, whether we're going to be up and running with the grand jury. At that point, then it becomes very important to get the signatures. So we've already started on that process. We have 250 people that have already volunteered. We have their numbers, emails, and all that. So we've already kind of organized this. We're going to try to rent a building so that we can have that open all the time where people can come in there, kind of have a meeting place for people to come back to. If the weather's bad, people can drive in and see us. We're going to set up, we're talking right now around the 20th to set that up, try to organize, try to get people and put them on teams. And that way we have one of our main organizers that we're in communication with all the time, reaching out to those. We will also be putting on our social media. So again, watch my social media, whether that's jj4ok.com, Justin Humphrey Facebook. Get on those. All the rest of those will have media also, where we will be telling people what dates we're going to have meetings. We will be live streaming some of those. We're going to be making videos. I've been trying to make a video pretty frequently, just to tell people, hey, this is what's happening. Don't give up. We're doing this. So again, we made a video here recently of the day we filed that. So I believe that was yesterday. My days are running together. So made a video showing that we'd promised you we're going to file this. And yesterday we did it about 4:00, went up there, filed it, gave the judge that. They've already agreed. My understanding is that we're going to move this out of, we're going to get a different judge, because we put all the judges on from Payne County. We put the DA from Payne County, Noble County, some surrounding. And as I said, we put all the Supreme Court justices, the judicial complaints, because again, we've told these people all this time and for quite some time. And this is not something that just happened overnight, Justin. This is something that we've been trying to tell, and we've been doing a very good job of documenting, telling these Supreme Court justices, telling judicial complaints, going to these judges, going to the DAs, and documenting their failure to take care of victims, their failure on these abuse cases. And so again, that's what we're calling them in, whether that be government officials, that we've also sent this to, the Attorney General that we've sent it to. We've had grand juries that were approved by the prior AG, and that this AG come in and stop that grand jury on one of these Payne County cases, big case. And so again, why would you do that? Why would, with all this evidence, would you stop these cases? And again, the family courts and all of the things that are going on. And again, Payne County we've seen some real problems in Payne County. This Butler case has really exploded it, really just shown it. But the big story is not just the Butler case. I don't want to diminish for the victims of Butler case, because it is big and it is important. But the bigger story is how many Butler cases are out there? How many cases similar, just as bad as Butler case, do we have right there in Payne County? And again, I began telling people, hey, you hit the tip of the iceberg. And they were like, yeah, Humphrey, sure, you bet. And then I go, no, go look at this case. And no, look at this case. And guess what? People that have taken the time not to just dismiss, oh, he's just making noise. No, the people who've taken the time to go in and look at these cases come back more shocked. I have not talked to anybody that hasn't gone, my gosh, what is going on in Payne County, Oklahoma?
Well, you had that Canyon Ryan Porter the other day, which was pretty much the exact same case.
Oh, absolutely. And again, when you're looking at the district attorney there, an ADA that got caught with significant, I mean, massive amounts of child pornography. And if I'm not mistaken, all these cases start running together. But if I'm not mistaken, I think that happened in 2022.
It did happen in 22 because I'm actually going to be talking about him in length here shortly. So yeah, because I feel like people need to know how rotten it is from within.
Yeah, and the big deal here's what I need your listeners to understand. If I'm a district attorney and a person working under me in the district attorney's office gets caught with 150 videos of child pornography, somewhere approximately there, I think I'm right. If that happens and I'm the district attorney, we're going like a whole hog. We're going after this boy like nobody's business. I mean, we are getting, get a rope. We're coming after you, son. You're an assistant district attorney and you're doing that and you're prosecuting people. I promise you that's going to be number one case that gets prosecuted if I'm the DA. Instead, we're sitting here almost 4 years later, and what's being done. And it does look to me like they're trying to sweep this thing. That's what it appears like. And I think it appears like that because it is like that. And so if that doesn't scream and smack of corruption and tell you, you know what I'm saying? I mean, if you have that much child pornography, we've all opened up our phone and seen something. My gosh, who put that on there? Or golly, that's borderline child pornography right there, and you try to get it off. That's not what we're talking about. We're talking about a guy who is collecting 150 videos of child pornography. And you're the ADA and you don't know that, bull. You know what I'm saying? So again, if you want to look at a case that tells you just how corrupt and how bad that district attorney's office is, I think that's the case that really you just take your hat off, put it right there.
We're talking about it. We're talking about it today in this stream. I have it towards the end because I want people to see how deep it goes. And yeah, and this was something where I think NECMEC, which is the National Center for Missing and Exploited Children, they got multiple tips. I think like 14 different tips. Meaning, and I don't know exactly how the tips came in, but in my experience, typically what happens is somebody downloads something that's already known to be CSAM, child abuse material.
Right.
And so then that automatically gets flagged to NECMEC. And then it triggers an investigation. And like, once it goes there, it's going to be an investigation. Right. So, anyways, that's kind of what happened here. And they had multiple, I think 14 bells went off.
Well, and the issue is just like in Butler's case, you have laws that say you got to contact the victims. You have laws that say, this is the process that you must go. And we have attorneys that, they're trained in these processes. So they know this is what they do. And so for them not to do this, it is an intentional, it is a knowing, so they knowingly, willfully, intentionally violate the law in order to get one of their friends, whether it's through favoritism. And that's what we're saying needs investigated. Because, when people ask me, well, what's the motive? Motive's always an important question. Why would they do that? And again, I don't see the monetary there yet. There's some monetary things we want to look at in corruption in the district attorney's office and in these DHS and some other things, especially some of the attorneys that represent this stuff. We believe there's monetary stuff there, and we will be presenting monetary stuff. But what I'm saying in the Butler case and in some of these other similar cases of why they won't either prosecute rape cases or why they give very, very lenient sentences out to people who you would think would be reserved for the most strict and serious sentences, and they're letting them walk and not even arresting them. And people are getting, one of the sex offenders getting 11 violations for protective order on one of the victims of a 16-year-old that he had sex with. Again, where is the court on all this? Where's the DA? Where's the judges? It's not just a breakdown in one of them. It's a breakdown in the entire system. How does that happen? we can always see like maybe one case falls between the cracks. That's one of those you go, okay, that's bad. We're not talking about that. We're talking about systematic right here, systemic. We're talking about many, many cases. We can sit here and I can name numerous cases. And then the big kicker is, Todd, you got to put this beside the fact that we have a couple of people who came in and reported abuse on child abuse. And this same court arrested them, one of them, an organizer, the previous organizer, when we tried to do a grand jury. They arrested him and put $1 million bond on him. I want to say, I was looking the other day, and I want to be careful and make sure that I say I think I did this, but I was looking because I've tried to keep track on their bonds and see, because the judge said, we put $1 million bonds on them all the time. Well, I can't find them if they do. And they had a guy stab, I think, his mother in the neck, and they put like a $50,000 bond on it. So $50,000, but yeah, you come in and report your kid as abuse, and then they try to put child stealing on you and put $1 million bond on you when you've been up there every day telling them the kid's right here. I'm not going to take him back until we get this abuse thing handled, which is, by the way, the law. That's what the law says to do. So this guy's trying to follow the law, and that judge stays late, gets $1 million bond and puts false charges on this guy. And you got to also know that DA who signed all that and did all that, which they backdated it, we caught that, was named in that grand jury. How do you issue warrants for people that like that, where you're working on the grand jury? And so that's the stuff that we see. We see these judges. We had the Supreme Court judge try to throw this case out, and he's in it. He's named in it. It's like we have to go back and go, Judge, how are you going to set on a case that you're the subject of? That looks a little, you
got to recuse yourself.
Yeah, you flunked Ethics 101. You need a remedial class, Judge. And here's what's funny. He actually removed himself after we called him out on it. So, again, that's the closest you'll ever get them to say, hey, he's right. They're not going to come out and go, okay, that's true, that's right. But when they recuse themselves after you call them out and catch them, then it smacks of problems. Those are the issues right there. How would you even do that? Why would you even do that? And why would you have to be called out on it? And again, we have one of the other judges that have come and said, well, on the last one, they threw it out illegally, I will say, and they said they certified the numbers. We asked them in Oakland court, how did you certify these numbers? It has to be board certified, and the board never met. The judge said, not my problem. That's not my problem. And so anyways, I went back and asked the board chairman, do you have, did y'all meet? Did you review? And did you certify? And the board chairman wrote me back in writing, never met, never reviewed, never certified. So again, here we have all of these cases, this grand jury and all these signatures being thrown out because they claim to certify them when we have absolute proof that they're sitting in court and lying about it. So again, these are things we're going to call in this second grand jury. We've called all of these judges. We've called the Supreme Court judge. We're putting them all on there and say, hey, come in here and answer how you're doing all of this. We're going to call them into account, and it's high time. It's time somebody call this stuff out.
Oh, I agree. Well, this gave us kind of the perfect opportunity to do it. You've been fighting like a bull, trying to get a lot of this exposed, and I obviously commend you for that.
Thank you.
And I'll tell you, I really hope. So for those of y'all who don't know, Representative Humphrey here is running to be the next lieutenant governor of the state of Oklahoma. That's going to be in the 2026 midterms.
Yeah, so that's going to be June 2026. Again, you can go to jj4ok.com, jj4ok number 4ok.com, or Justin Humphrey Facebook. But my big deal is going to be corruption. We have my hopes is that we'll look right here in Payne County, and what we do in Payne County is going to go around this. This is going on throughout the entire state of Oklahoma. I just got through reading some stuff and Justin, you know better. You're keeping up with more. I try to watch some of your stuff, and you're keeping up with the whole nation and calling stuff out. Kudos to you. But I just got through reading a Supreme Court judge there in Baton Rouge, Louisiana, and he just blistered all of them on what's going on in all of these family courts and the stuff that we're talking about, Justin, the favoritism, the cabal, the judges taking care of each other, all these groups going out to parties and hanging out with each other and discussing this off to the side and deciding these cases. And so all of this is not the way that the court's supposed to run. If you go in per se, if you're trying to represent yourself, hey, they're just dismissing you and just treating you like trash because you don't have a law degree. Well, guess what? A lot of people can't afford an attorney. And a lot of people are trying the best to keep their kids. And we see them taking kids for absolutely. I'm convinced that a lot of these DHS workers are allowing kids to remain in abuse, not even getting them out of abuse. But if you stand up to them and say, you know what, I spanked my kid, yeah, but that's none of your business. You need to get out of here. Guess what? You're fixing to have your child. If you stand up to them, they will go after you like great guns. And if you try to defend yourself, the court will go after you and hold that against you. And that's what we're seeing. That's what they said in that Baton Rouge. They come out with a whole laundry list. And when I'm reading that, I'm going, that's everything they're claiming right here is going on right over here in Oklahoma. It's the same list that we're talking about.
Well, and I want to remind people too, this is kind of a little bit off topic, but you're talking about DHS not doing their job, as we're all focused on Jesse Butler and, and unfortunately, yes, I cover stuff across the country, but Oklahoma is giving me a lot of stuff lately. And for a state that's not as populated as a lot of like California or Texas or Florida or New York, you guys are a large percentage of the cases I'm covering right now. But I want to remind people that, and I know you're going to want to talk about in a second, that little 11-year-old girl a couple months back that, that gave birth at home by like that DHS was called multiple times. And, even when you saw the squalor that she lived in, they never once stopped. So yeah, there's a lot of problems. And I'll say this too, and I've talked to you about this, if you watch my stuff too, that we got this petition, which is now up to almost, I think, 150,000 signatures to end. And it says to end plea deals for child predators. I know that you can't get rid of all plea deals, but I'm referring to the easy ones, things like what Butler got. And I hope that you become the next lieutenant governor, because I'm going to start with Oklahoma if you do.
Hey, you know what? We've got to do something to do, whether it's a review. One of the things that I would say, and we'd have to talk about on what you're saying, because I like what you're saying, but you got to make sure if you write in there that won't make DAs stop reducing sex crimes. So instead of filing sex crimes, the way they get around your deal, they just don't file it as a sex crime and they file something. So again,
you have to figure out a way around it, but you get where we're going with it.
Oh yeah, you got to start somewhere. You got to call it out, and you got to start somewhere. So absolutely, kudos to you. Here in Oklahoma, I used 35 years of law enforcement experience, and I have an office. I bought an old store, and I've got a pretty big office, and I got a filing cabinet in there. We call it, I'm gonna keep it G-rated. We call it sketchy stuff file. And guess what? My sketchy stuff here in Oklahoma, that file's almost full. I'm going to have to start a sketchy stuff 2 filing cabinet.
I'm not laughing because it's funny because it's terrible.
Yeah, I mean, I cannot keep up with all the stuff that we're getting called out on. And as soon as anybody finds out that you will actually try to help, you just can't stay up with all the calls. And I originally used to start going, oh, I don't think I could believe that anymore. I start off with, okay, I better look at this. This sounds, we just see case after case, whether it be rates that are dropping. And the thing about it is what infuriates me is the people they go after, and they get mad at people and they go after stuff that just doesn't amount. Like my friend who called out the abuse, like the grandma who calls out abuse on her grandchild, and they end up arresting her because the state took the grandkid because the abuse was substantiated. State takes the grandkid. The DA files a warrant on grandma because she won't give the kid back, and the kid's in state custody. I mean, you can't make this stuff up. And they go after that, but they'll turn around and let Jesse Butler walk out with 150 hours community service, or they'll have 5 rape cases that they know about for over a year. They have good cases on them, and they got to go hire a lawyer to try to get the DA to do their job, and file. When did victims have to hire attorneys to get the DA or the OSBI or one of these law enforcement groups? And again, I do want to come out and say, the PD there, some of the deputies and the police officers have done an outstanding. I mean, you know what I'm saying? We always want to let people know I'm a law enforcement officer. I applaud the work that many of these law enforcement people do. They've come back. Some of them even have come in and apologized for some of the stuff that they've had to be part of or do. They're awesome. What we're looking at is their administrators who will go in and go arrest people that they know are lying about, go in and take kids and put them in abusive places, all because they have people of influence wanting them to do, people of political power wanting them to do these things, and they're using their positions for political power and favoritism. It looks like to me that's the allegations that we want to investigate. And here's the bottom line. The question is there enough to warrant an investigation? Is there enough to warrant a grand jury? And guess what? Look at the Butler case. Look at the case of the DA who hasn't ever been prosecuted for 4 years with all of that child pornography. Look at these teachers who are walking the streets, who are molesting kids, getting away with it, and continue to violate protective orders on these kids. And then let's start talking about the child abuse cases that are being swept under the rug. And we haven't even started into the financial issues that we have that are being behind a lot of these same issues. So I think there's more than enough to warrant looking into Payne County. I think it's over past time that this should be done. And I think we're going to get it done, Justin. I really believe.
I think there's too much heat on it. And what's been really interesting about this case is typically in the news cycle, cases like this, they don't stay that long. This one's not only had staying power, it's been growing. The momentum behind it has been growing exponentially. In fact, I think there's the Facebook group that's up to I think 7,200 people now in it. Corruption, Stillwater, Jesse Payne. You can look it up. Jesse Mack Butler, Dan. If missing, he's on my YouTube or my TikTok. He can pin it, and I can tell people he runs the group. But it's really been growing exponentially. The other thing before I let you run, that I do want to put on just to put in your ear as a bug. I don't even know if this would be legally possible. This would be a different discussion. But I kind of met a point where I feel like, when you look at somebody like Jesse Mack Butler and you look at the strangulation that he's done multiple times, that he's filmed it, right? We know that he's very comfortable putting his hands around somebody's neck. When somebody does that, the lethality of it goes up 750%. So it's not a matter of if, it's a matter of when he ends somebody's life. And I kind of feel like when you have judges like this that are so lenient, so soft on crime like this, if and when that happens, or if the victim, you let somebody out and the perpetrator, ends the life of the victim or something else happens, you as the judge or the DA might need to hold some accountability to that. When you're that soft, I don't know how you'd write that, but I mean, I think that's just a thought to put in someone's ear.
No, I think, Justin, if you've been looking at what's happened in North Carolina and some of these other cases where people have repeatedly done crimes and get out and stab somebody or commit heinous crimes like this. And the thing that you're not saying, Justin, is I don't know what judges training looks like, but I know what law enforcement training looks like. And I know that I've been through 10,000 domestic abuse trainings, so many that you go, oh, no, not another domestic abuse training. But again, you learn a lot in training, and training is great. We need to always do more training. But one of the things you learn is about in domestic abuse and strangulation. And you do know through your training that when you see these kind of acts that, yes, you're looking at the likelihood of this type of violence continuing, and that there's a great likelihood that, you could see permanent damage or you're going to see a death. And so, again, we see this as not just there are little trends where kids choke each other out and are playing around. And this is not one of those trends. This is not, You heard the testimony of that girl. He choked her, you know, to the point that her neck had to be operated on. He choked her to the place that she was 30 seconds away from death. That's not any playing around. That's not, you know, just going a little past playing around. That's being very sadistic. That's being very brutal. And that's close, like you say, 30 seconds away from death. That's about as close as I'd want to get. You know what I'm saying?
I wouldn't even want to get that close.
Too close. Yeah, I don't want to get that close. And so the thing about it is are we going to sit back and wait? And do we have to sit back and wait to see something happen? And I believe, well, I know there's another victim in this case, so we know that's not just that victim, you know, and so again, there'll be other victims out there. And that's the thing that we have to establish. Why would victims want to come forward if they're going to have to open up their entire lives, come out to all of this public, you know, scrutiny, and then turn around and get 150 hours community service, if he even does that? And we're already seeing, you know, did he take this seriously? Did he take this seriously? Well, let's look at how he's doing as he's on his supervision and what's going on with that. And based on what I've seen, it doesn't look like, because I mean, I'm going to tell you that if I was looking at 70-something years and I got 150 hours community service, this boy doesn't have 300 hours in. I'd be out there cleaning streets. I'd be out there, you know, singing in the choir. His brother would be doing all the things that you would see, some real humility. You would see me doing stuff that would show the community, I'm sorry, I messed up, and I'm going to make this, you know, as right. You can't never make it right, but as right as it could. That's not what you're seeing right now, or it doesn't appear to be what I'm seeing right now. So again, you know, what are we going to see later from this person? Are we going to see, and if they do, should the judge, should the DA be held accountable? I think it's a conversation we definitely, you know, again, we're getting on some, you know, we want the DAs and judges to be able to do their job, but I think what we have to talk about is gross negligence. And I think when we see
that's the thing. If they did their job, this wouldn't be an issue. If they did their job, Jesse would be sitting in the penitentiary right now.
You know what, Justin? If they give him 5 years in the penitentiary and 15 years out on paper, I don't think anybody would even be really saying too much. You know what I'm saying? But
I agree. I don't think it'd be enough time, but at least it was something.
Right. Well, I agree with you. But what I'm saying is, I think if they would give him something, I don't think you would see the outrage that you're seeing. I think this 150 hours of community service has created outrage. And like you said, this ain't going away. This is gaining momentum. I think the fact that we've been able to show that this is an ongoing pattern. When you're looking and investigating things, you look for patterns. You look for the repeated over and over and over again. And what we're seeing in Payne County is Jesse Butler is not just a one-time drop-down case. It's a consistent pattern of what's going on in that county. And I believe what's really across the state making waves is people are seeing it. Hey, we got the same thing over here. We got the same thing over here. And they're wanting justice to be done. And I think that if we see that here in Payne County, that we're on I think we're going to start down the hill doing some good work across the state. But it has to start right here in this case.
Yeah, I agree. I think it's going to open the floodgates. Well, that all being said, I appreciate you jumping on. I know you're a busy man. You're always in a lot of different places at once. Keep me posted so I can keep them posted on, you know, when signatures are going to come out, when you need them. And just so people who know, I know a lot of people hear this and like, man, I want to jump on. I want to sign the petition that Representative Humphreys is doing for this grand jury. You have to, for mine, you can sign the one to end plea deals for child predators, linked in my bio if you're watching on TikTok or Instagram. And then if you're watching on YouTube and Facebook, it's in the show notes. But for his, for the grand jury, you have to be not only a resident of Payne County, Oklahoma, you have to be a registered voter in Payne County, Oklahoma. So here's what I'm going to encourage you to do. If you live in the Payne County, Oklahoma area, if you have a family that is, make sure that number one, they're registered to vote, but also stay on top of this because they're going to need as many signatures as they can get. It needs to be one of those things where they have so many that there is no way that it can bring a denial.
Absolutely. Hey, I appreciate you telling everybody that. We'll put out a video Monday just to kind of say, hey, this is where we're at so far. We hadn't heard I don't expect to hear back from the court by Monday, but somewhere Monday, Tuesday, we'll stick out a video and just let people know, hey, this is where we're at so far. Y'all guys expect somewhere around Wednesday for us to have an answer to that. And if we can get that answer by Wednesday and we're on, if game's on, we're already lining up for that weekend to start the process and start gathering these signatures. Guys, we need around 5,000 signatures. Takes probably 35, but we got to get more than enough so that we can't give no wiggle room. If we give them wiggle room, they'll knock us off there. So we want to do about double, and we think we can. And with your help, with the county's help and the people in the community, we're asking your help. This is the right thing to do. We're not about anything but the truth, to get to the truth and hold people accountable and set the court. Let's get our court system back, and let's have justice for everyone, for no matter what race or gender or public party you belong to. The lady's blindfolded. She's supposed to not be looking at all that. And that's what we want, is to get our court system back.
I love the way you put that. Well, again, thank you so much for joining and jumping on. And yeah, definitely keep me posted on Monday and then whatever else. And as soon as you give it to me, I'll make sure that we get it out there.
Awesome. Appreciate you, brother.
Thanks. Have a good one. All right. Well, I appreciate Representative Humphreys joining us today. So let me put this back up here. So we have a couple more things to talk about. So again, that grand jury, I'm going to move on to this real quick. Let me switch the slide. There we go. Before I get on talk about this guy in a second. That's very important. That's going to be how some accountability happens. And he's going after everybody, basically associated in Payne County with the judicial system. And this is going to be what I'm about to share with you is another reason why, because when we zoom out for a minute and you start digging into the Butler case, which we've done, as Representative Humphreys was saying, a bigger question kind of comes up. And honestly, you know, y'all have said it. He said it. The question is, how long has this been going on? How deep does it go? If what we're seeing here were isolated, as he was saying, that would be one thing. But when you look at other cases out of Payne County, Oklahoma over the last few years, you start to see issues that didn't begin with Jesse Mack Butler, and they didn't end with him either. And that brings us to this guy. It's up here. Am I pointing the right way? This guy right there. Well, I'm trying to. There we go. Him. And this case matters for context. His name is Kevin Etherington. And this is a completely separate case, completely different defendant, completely different charges. This is one that we were talking about. And I want to be very clear about that because it's relevant because it involves the same courthouse, the same system in the same period of time. And it raises serious questions about how cases involving children have been handled in Payne County, Oklahoma. Let's talk about Kevin here, because Kevin Etherington was not a random person in this system. He was the first, listen carefully, the first assistant district attorney in Payne and Logan counties. Essentially, he was the number 2 prosecutor in the entire office in the county. He wasn't just handling cases. He was helping to shape charging decisions, internal policy, and how serious crimes, including crimes against children, how they were approached. Then in November of 2022, so we're talking 3 years ago, over 3 years ago, Kevin was arrested. According to OSBI reporting in court records, that arrest came after 14 cyber tips from the National Center for Missing and Exploited Children came through. They pinged, that's what we were talking about earlier. OSBI agents searched his Stillwater home. They seized evidence, and he was booked on aggravated possession of CSAM and computer-related violations. Okay? Again, that arrest happened in November of 2022. We are now approaching 2026. And according to the official OSCN docket, Etherington's jury trial is currently scheduled for March 3rd, 2026. But there's a caveat, okay? And I'll get there in a second. That is more than 3 years between arrest and trial with no conviction, no trial, no public resolution in the meantime. And he's out just walking around. And I've been told, but this is not confirmed, keyword not confirmed, that he is still working as an attorney, meaning that he's still part of the bar, despite getting hit with multiple, like Representative Humphrey said, over 150 videos of CSAM, 14 flags going off at NECMEC, and an investigation that shows it. Okay. All right. Now, there's another documented fact that raises serious concern, because on the very day Kevin Etherington's case was filed, every single Payne County judge recused themselves. Every single one. The case had to be reassigned to a judge from another county because the conflict inside Payne County courthouse and the Payne County, I cannot talk, or he's getting dry. Inside the Payne County courthouse were considered too significant, meaning they would rather wash their hands of the situation, everyone in the county, as opposed to a trial where they have to put victims first, which, Payne County apparently doesn't like to do. It's also important to understand how Kevin Etherington got into the position that he had. He was hand-selected and hired by District Attorney Laura Thomas, and he was installed as her first assistant DA. Why does Laura Thomas sound familiar? Well, a few minutes ago, we read her statement in regard to Jesse Mack Butler. We read her statement because she was in the courts. She was in the court system on those transcripts. All right. Now, Kevin worked closely with the same judges, attorneys, and court system that later handled Jesse Mack Butler's case, or is now handling. Now, I want to slow down here and I want to be careful, okay? Because these are allegations that are circling locally from multiple sources that raise questions about how power has been exercised inside this courthouse. You guys need to listen very carefully because this is important. These allegations have not been adjudicated, so I'm going to clearly separate what's alleged from what's documented because we're talking about lawyers and judges, and I don't want to get sued. Multiple sources allege that Judge Culling, that's the regional presiding judge, the one that oversaw the hearing yesterday, or sorry, the other day on the Jesse case, was involved behind the scenes in crafting the plea agreement in the Butler case. Okay, something that under normal procedure is the responsibility of the district attorney's office, not the bench. And again, I want to state that those claims have not been proven in court. Those are at this point rumors. They are alleged. What is, however, documented is that Judge Worthington, who serves under that presiding structure, enforced the plea agreement that resulted. There are also allegations, again, keyword allegations, that individuals connected to the Etherington era inside the courthouse may be contributing to the prolonged delay in Etherington's own case. What we can say with certainty is this. Etherington's case was stalled for years. Every local judge recused themselves immediately. Now the trial is set more than 3 years after his arrest. When you place that next to what we've seen in the Butler case, the minimization of violence, the exclusion of victims, lack of transparency, people are understandably starting to ask some pretty hard questions. Not because these cases are the same, because they're not. Not because these facts are identical, because, again, they're not. But because cases involving children, abuse, and people in positions of power keep following a familiar pattern. Delays, quiet handling, and outcomes that don't seem to match the severity of what's alleged. Now, this doesn't mean conclusions should be jumped to, but it does mean that scrutiny is warranted. And it helps explain why the community is no longer satisfied with the internal explanations and why people are calling for outside review, independent investigation, and transparency. Because when this many red flags keep appearing in the same courthouse over the same period of time, it stops feeling like coincidence and starts feeling like something that needs to be examined. Okay, guys? Now, I want to end here. None of this happens. I want to say this, actually, sorry. None of this happens if people don't pay attention. And the fact that so many of you guys have been paying attention, asking questions, showing up, showing out, refusing to let this go quietly, that matters. In fact, you guys get a round of applause for that. Because that's what we need. That's what we need. Y'all are the reason this case is so big. Y'all are the reason why all of this is being looked to. Y'all are the reason why there's now going to be a grand jury that could possibly bring out every single person involved in this case. Right? That's because of you guys. So pat yourself on the back for that. Now, if you haven't already, like I said earlier, please take 2 seconds to sign the petition to end those easy plea deals for child predators. The link is in the show notes here on YouTube and Facebook. And if you're watching on Instagram or TikTok, it's linked in my bio. So please make sure you're following, subscribed, and that notifications are turned on, especially here on YouTube. Subscribing is free, and it genuinely helps me covering cases like this. I'm working towards 100,000 subscribers, and that reach makes a real difference. This live will stay up, so if you missed any part of it or you want to go back through the documents we talked about, you can rewatch it here at any time. I'll also be on News Nation tonight, continuing this conversation. And most importantly, thank you all for caring about the victims. Thank you for listening, and thank you for not looking away. We'll keep going, and until next time, stay safe, stay aware.